Good morning. Welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Brandy Baker. Ms. Baker is outside meeting with Mr. West, so she is here. Robert Campbell. Here. Kyle Holland. Present. Stephen Pickron or Stefan Pickron. Let's see. I show that he is confirmed in the Lyncher unit, serving 5 years out of Dallas County. Projected release November of 28. Whatever that's worth. We'll recall that one. Isaiah Rosser. Here. Smith Black. Here. Edward Drummond. Edward Joseph Drummond. Donald Ellis. Here. Dallas Hightower. Dallas Justin Hightower. Gerald Holmes. Here. Jason McDonald. Donnie Sanders. Donnie Lee Sanders. Robert Wells. Amanda Wellborn. Preston Wilson. Preston Mitchell Wilson.
I believe he's in a federal detainer in Henderson County.
Carrie Sanders. Here. Daytona Blue. Aaron Ross. Here. Curtis Smith. Here. Jesse St. John. Here. Tammy Jones. Here. Jeremy Treadway. Here. Is there anyone who's present in the courtroom and your name's not been called? All right, counsel, we have anyone ready? Not everyone at once.
Hi, Judge, can we approach?
Yes. All right, this is cause number CR 22, state of Texas versus Harry Lynn Sanders, Mr. Clinton set pre-trial today. It's my understanding that the bank viewing discovery has requested additional pre-trial setting. State having no objection to it, the board is setting Mr. Sanders for the next pre-trial date of August 15th at 9 a.m. Once he signs and gets his notice, he's free to go.
Thank you, Judge.
Mr. Walter, let's go ahead and we'll just announce on CR 24-39 this afternoon. In custody is Mr. Ronald Jack Edwards. It's my understanding that we were also set for pre-trial on Mr. Edwards, and that defense is in the same position, just received additional video discovery from the state. And the defense has not had opportunity to review that at the time. The court finds that the state having no objection to resetting that matter. The court resets Ronald Jack Edwards to pre-trial on August 15th as well.
Thank you, Judge. Good to see you.
Roy, you ready?
Yes, sir, I am.
Who are you ready on first? Tammy Jones or Jeremy Treadway?
Miss Jones is.
Okay. Just you're asking, we said it to additional document.
I need to plead.
Oh, please. Okay. She's here at the courtroom with you.
Yes, sir.
Can you go ahead and bring her up?
Yes, sir.
For the record, cause number CR 24-24. State of Texas versus Tammy Diane Jones. We're set for docket call today. Mr. Wyatt, you're asking for Ms. Jones' case to be set for a plea before the court.
Yes, sir.
How much time are you needing?
30 days is sufficient.
Got August 13th and August 15th.
Let's do August 13th, Your Honor.
All right, court sets Ms. Jones for plea on August 13th at 9 a.m. And we'll need to set Ms. Jones the way we did before so that she can review the plea visually. Is that correct?
What I plan to do, and I'm going to speak with the DA's office about this. I'm going to try to get the plea papers early, have her come over to my office beforehand, so we have plenty of time to get that worked out. But we'll get something set up in the courtroom so she can see what you're saying, Your Honor.
All right, I'll make a note and we'll get that set up with Ms. Grisham. Try to do it like we did last time.
You can go,
Ready
Your
to
Honor.
go. Ready, Mr. Treadway?
Yes, sir.
Jeremy Treadway, CR 24-8. All right, Mr. Treadway set for a docket call. Go ahead, Mr. White.
Your Honor, the state has made us an offer. I need to talk with Mr. Treadway about that. I'm going to ask for a final docket call. I think this is our second call anyway, but I just need a little time and then that'll be the final.
Do you need 30 days or less or?
30 days will be fine, Your Honor.
All right, court sets Mr. Treadway for August 13th. Final docket call, 9 a.m. Is that all you have, Mr. White?
Yes, sir, that is.
Do you have anything on the afternoon docket?
No, sir, I do not.
Go ahead. All All right, Mr. Jeff White, are you ready?
Yes.
Who are you ready on?
On this one, Curtis Smith.
Mr. Smith, you'll come forward. This is cause numbers CR 24-64 and 65. Shows Mr. Smith is set for pretrial in each case.
That's correct, Your Honor. What we would be asking is the court to set this for August 13th for docket. I think that there's a very strong possibility we'll be able to get it resolved in 40 days.
All right, and with regards to, there's no contested pretrial, just your usual pretrial motions.
The usual pretrial motions, I didn't have to add any from the last time.
All right, Mr. Smith, have you met with the pretrial release office? You've done that. You've met with Mr.
Yes,
West. Okay. All right, then the court sets Mr. Smith in each case for docket call on August 13th at 9 a.m. And since you've already signed your conditions of pretrial release, you're free to go.
Thank you, sir. You sign right there. I'll get that paperwork. Judge, either one of the next will be fine.
No.
Okay, all right, yes, sir. Thank you, sir. Aaron Ross.
Aaron Ross. Four say versus Aaron Logan Ross for docket call. Go ahead, Mr. White.
Your Honor, we're going to be asking for one more docket call. I think we'll be able to resolve all the issues. I spoke with Ms. Curry about this and she does not have a problem. If we could have it set on the August 13th docket, I think we'll be able to come up with the resolution or ask to place it on jury's docket.
No objection to a final docket call, Your Honor.
All right, and the board says Mr. Ross for a final docket call August 13th at 9 a.m. And once he gets his notice, he's free to go.
Thank you, sir. Have a good day, sir.
Next one be Jesse St. John.
Cause number CR 24-36, State versus Jesse Ryan St. John for pretrial.
That's correct, Your Honor. Don't believe that we had anything new that we presented from the last pre-trial and everything was agreed to. We would just need to have it set for hopefully the August 13th docket, and we'll probably be able to have a resolution at that time.
All right, court finds there are no contested pretrial motions, therefore sets Mr. St. John for docket call on August 13th at 9 a.m. Once he signs his notice, he's free to go.
And Your Honor, on blue case, we'll be going over the paperwork. So please.
Yes, sir. As soon as you get that done, let me know. I can work it. I'm not sure that I called there. I'm sure. Set that. Page 4. I didn't see that. Schmidt, great. Who would you like to call first?
Elizabeth Black.
Elizabeth Black, you'll come forward, please. This is cause number CR 24-91 for arraignment.
And Judge, Ms. Black understands what she's been charged with, range of punishment. Her name is correct. We waive formal reading and her plea not guilty, ask for a pretrial stay.
What date are you looking at, Mr. Schmidt? I've got August 13th, 15th is August 13th, sufficient to give you vacation. Letters are,
13th to the 15th is fine, whichever is better for you.
Tuesday is the 13th. That's your typical day, right, Tuesday? All right, court finds that Ms. Black has waived the formal requirements of arraignment. Court enters plea of not guilty into the record and sets this case for pre-trial hearing on August 13th at 9 a.m. Ms. Black, have you already met with the pre-trial police officer, Mr. West?
Yes, sir.
All right, so there's conditions of all release that you must sign, follow. Now, violation of those could result in the court finding bail insufficient, or could put you back in jail. So these are going to be things, we're going to go over all the paperwork with you, but things such as not committing new offenses, not doing drugs, not drinking alcohol, not carrying firearms, things of that nature. Okay?
Yes.
So make sure that you meet with Mr. West. We'll be here and see Ms. Burns.
Yeah.
And we'll give you more information and get you on the way. Who's next?
Judge, I have Edward Drummond. It's my understanding from Ms. Taberham that Mr. Drummond is in Terrell State Hospital. Have we confirmed that, I think?
I think we're waiting for confirmation from Mr. Pickett's office.
I got Donald Ellis.
Donald Allen Ellis, CR 2483. All right, Mr. Ellis, is set for pretrial.
That's correct, Judge. As of today, we have no contested pretrial matters that need to be addressed. We'd ask for docket call, sir.
All right, court sets Mr. Ellis for docket call August 13th, 9 a.m. Once he signs his notice, he's ready to go.
Your Honor, if I may, just to address Mr. Ellis, it's come to my attention that there may be some attempted contacts with witnesses in this case. Just like to inform Mr. Ellis that would be a violation of his bond condition. He would be taken into custody if proven before Your Honor. So I just ask that he not make those attempts or go by places where they may be found.
Do you understand what I'm saying?
Yes.
Understand, Mr. Ellis?
Yes, sir.
All right.
Thank you.
I haven't contacted nobody.
Good.
Oh,
Robert Wales.
Robert Wells. All right, this is cause number CR 17-266, State versus Robert Michael Wells, and we're just on a compliance again today, I believe, Mr. Schmidt.
Judge, we've been on compliance to give Mr. Wells an opportunity to catch up on his community service. We are still not in compliance with that. There are some issues that Mr. Wells has that he's going to provide me documentation for so that I can provide to the state as well as the probation department. But at this point in time, we can either carry him again for another compliance, or if the court wishes, or the state, we can set him on a regular docket date.
Position on state.
I mean, we'd obviously ask for compliance, but
Your Honor, I'd go ahead and request a compliance check just so that I have a chance to meet with Mr. Schmidt and go from there without having more information. I'd hate to set this on a docket setting to proceed if it's something where we may not proceed.
All right, court will set Mr. Wells for an additional compliance. I'm just going to set it 30 days, Mr. Schmidt.
excuse me, sir.
I'm going to set it for 30 days.
That's fine, Judge.
All right, court sets Mr. Wells for August 13th. I am.
Like post it. Amanda Wellborn.
Amanda Wellborn, CR 24. All right, Ms. Wellborn, set for arraignment.
That's correct, Judge. We understand the charges, name spelled correctly, wait formal reading, and are plea not guilty. Ask for that August 13th pretrial date.
All right, the court finds that Ms. Wellborn, having waived the formal requirements of arraignment, enters her plea of not guilty into the record. Court then sets Ms. Wellborn for a pretrial hearing on August 13th, 9 a.m. Signed your release.
Yes,
You have done that. You've received a copy of those.
yes.
Right. Once you sign and get your notice, you're free to go.
But we have Gerald Holmes here. He was notified yesterday on. So we're here, we could get him set for.
Yeah, counsel, if you'll approach on that. All right, this is call numbers CR 24-55, similar. -56, 57. I believe that the state and the pretrial release department had requested a hearing on some concerns with Mr. Holmes' conditions of pretrial release. Court finds that the setting today is insufficient notice to the defendant and his counsel. Court finds that Mr. Holmes is already set for August 13th. And so the court will carry over a request for the hearing on the pretrial release conditions to August 13th at 9 a.m.
So, it's free to leave, Judge.
There you go.
All right.
Kyle Holland. All right, this is a sanctions court hearing. All right, good morning, Mr. Holland.
Good morning, Your Honor.
All right, looks like our last sanctions court hearing, we assessed 3 days in jail for a violation, I believe it was related to alcohol, correct?
Marijuana, sir. Yes, sir.
Yeah, all right, so my notes reflect that you served your 3 days in jail.
Yes, sir.
Yeah, you have the restaurant, correct?
Correct.
That now. And it looks like you paid your probation, you paid your court collections, you did your 20 hours community service. Where did you do your community service?
First Monday.
Okay. All right, so what I want to do is I want to reset you, bring you back, and I'm gonna order you to do the same thing, $60 to probation, $125 to court collections, 20 hours of community service. All right, and I want you to continue to in your IOP classes in Dallas, okay?
Yes, sir.
All right, so no jail time this time. That's good, right?
Yes, sir.
All right, 3 days that you get back. Let's bring you back on August 13th. So I want you to have all of those things turned into the probation office by Friday, August 9th.
Yes, sir.
All right.
Yes, sir.
All that done by Friday, August 9th, by it turned in. So if you're reporting your stuff to Dallas County, just know that it's probably gonna be a little bit of lag time between the two. So the earlier you get that turned in, the better it is for you and for me that it makes it into the report.
Yes, sir.
Okay, any questions?
No, sir.
All right.
Here you go.
Mr. Rosser? All right, this is sanctions court hearing, cause number CR 21-239. Zaire Rosser. Mr. Rosser, how are you doing?
Doing all right, sir.
Doing well?
Sir.
All right, let's kind of go over what you're here for today. You've never been in sanctions court, have you?
No, sir.
Do you know what sanctions court is?
No, sir.
Any idea?
Basically, ready for my payments.
Yeah, could be for payments, could be for a lot of different things, but the purpose of sanctions court is it's an intervention program in this court where this court tries to intervene with probationers who are falling behind. Either they're in violation and it's a technical violation like money, or it's a violation like not doing your community service, not doing your classes. It's not for people who, if you commit new offenses and don't report, those are motions to revoke, right? Typically, and so sanctions court is a chance for us to try to get you back on the right track so that you don't fall further behind and get yourself in a position to where you're going to end up getting a violation filed against you. Right. And so I'll go over a few things with you. It looks like you started your probation in this court in December of 22, and you got a 3-year term, which means that you're set to expire in December of next year.
Yes, sir.
Right. That probably seems like a long time away for you, but it's really not.
Yes, sir.
Right. I mean, you're talking about 1.5 years. The problem that we have now is in the beginning, you had a 3-year period to get a bunch of things done.
Yes, sir.
And you've been doing some things, but not all things. Okay.
Yes, sir.
So some of the things you haven't been doing, like your community service, you have 350 hours that you got to get done in a year and a half. You had 3 years to do it. Now you have half of that,
Yes, sir.
right? And you're behind on your payments. So what we need to do is we need to get you back to, and I know you and your family have made some payments towards your probation fees and stuff. But what we have to do now is we're going to prorate what it is that you have to pay based on when you're supposed to expire. So that's going to elevate your payments. Does that make sense? It's kind of like buying a car. If you go in and you tell them, hey, I want to buy this $20,000 car, and you finance it over 3 years, your payment's going to be smaller than if you finance that over a year and a half, right?
Yes, sir.
So position you found yourself in now, because you're so far behind, your payments are going to have to go up so that you can expire on time.
Right, to pay more money, that way it'll be
Exactly.
paid before the debt.
Exactly.
Yes, sir.
Because if you don't, then either they're going to, state may file a motion to revoke, or they may have to ask the court to extend your probation period so that you can pay off all these things.
Yes, sir.
And when you extend, it's going to add additional payments. It's going to cost you more money.
Yes, sir.
That makes sense?
Yes, sir.
So this is what I want to do. We need to figure out, what you're going to do on your community service. You haven't worked any community service.
I'm sorry.
You haven't worked any community service, correct?
Yes, sir.
All right. So do you have a job?
Yes, sir.
What do you do for a living?
I'm a contractor. I work 7 days delivering appliances for Lowe's.
So you're going to have to figure out when you're going to make time to get your community service in. And right now, if you were to expire by your date, which is December, right before Christmas next year, you're going to have to work 25 hours a month just to get done,
Yes, sir.
right? So that's a lot of hours. When you were originally placed on probation, it was 10 hours a month.
Yes, sir.
It's 2.5 times that now because you haven't worked any, right? So you're going to have to start figuring out how much time of the week coordinate off to dedicate just to community service,
Yes, sir.
right? And I'll tell you this, if you can, if you want to come down here and do your community service here locally,
Yes,
so
sir.
you're in Dallas, correct?
Yes, sir.
Right, if you want to do your community service down here, we have the flea market every month. You can get 50 hours for a weekend, right? 50 hours for an entire weekend. That's Thursday through Sunday. Yeah, so if you can dedicate a Thursday through a Sunday, and I know that's a lot of days in a row with a job, but you're
Yeah, I ain't gonna
in
be.
prison or in
Yeah, you
jail,
know what I'm saying? You ain't gonna be able to work a job. Yes, sir.
you know?
Yes, sir.
So if you want to do that, I'm just telling you, talk to your probation officers, talk to these probation officers before you leave. You could knock out that time pretty quick at 50 hours at a time. Doesn't mean you have to do that every month, but if you could do 50 hours, then that
And not, yes, sir.
we're looking at minimum 24 hours, I'm sorry, 25 hours a month. One weekend could take care of 2 months,
Right.
right? So if not that, then you're going to need to figure out when you can do it in Dallas County, make sure it's approved. But we're going to have to do a minimum of 25 hours in order for you to expire on time.
Okay.
Also, your probation fees are going to be $75 a month instead of 60.
Okay.
Okay. You need to pay towards your court costs, that's your fine, court fees, those things. That's going to be $150 a month. So that's got you up to 225 already. Okay. I'm going to write all this down for you. Okay. And then you also have to pay $25 a month for your UA fees because you're behind on that.
Yes, sir.
Okay. So that should be $250 a month. It's $250 a month.
$250 a month,
$250 a month,
all the way up until,
all the way until you're done.
okay, and then
December
25
hours of community service.
a month.
So one of those is going to be competing against the other. Right? Because you're going to have to take time off work to do your community service. When you take time off work, you don't make as much money.
I don't get paid.
You're going to have to figure that out because these are your obligations. And both of them, one can't take a backseat to the other. You can't say, well, I'll do all my community service and I'm not going to pay anything for a while. Or I'm going to pay everything, but I'm not going to do my community service. Because where you're at right now, that's what you're going to have to do to be able to be off probation at the end of next year. Okay. And you're on deferred right now, which means that you've got a great opportunity to have your case dismissed without being a convicted felon.
Yes, sir.
Do you have any felony convictions already?
No, sir.
All right. You don't want to have a felony conviction on your record.
Yes, sir. I know.
Don't. I'm telling you. That would haunt you for the rest of your life. Every job you get, every background check you take, every time you apply for a car, for a home,
Yes,
all
sir.
those things, right? I'm talking about messes your life up, right? So you're still in a position, the purpose of the sanctions court is to try to help you seize that opportunity rather than just say, Mr. Rosser's way behind. He's not doing his community service. He's way behind on his fees. We're just gonna file a motion to revoke, have a hearing, revoke him, put him in prison, have him serve his time, kick him out and go do what he does. That's what we're trying to avoid.
Yes, sir.
But we can only do our part. You're gonna have to do your part,
Yes, sir.
right?
Right.
You don't do your part, you're gonna force me to do my part.
Exactly.
Make sense?
Yes, sir.
Okay. All right, so what I'm gonna do is I'm gonna bring you back on August 13th.
Okay.
So that's what, 30, that's 30 days plus a week, so that's probably about 5 weeks or so, maybe 5.5. So you're gonna need to figure out this community service pretty quick.
Yes, sir. Get the
Right.
ball. Yes,
So
sir.
you need to have everything turned in by August 9th. It needs to be in the Van Zandt County Probation Department, August 9th by noon, where you did your community service and all of your fees paid.
So I just need, so by the 9th, I need to have everything at least,
You need to have everything paid and your hours already turned in. If you do them in Dallas, you do your hours in Dallas, you need to have those things turned in
so
before the 9th so that they can get down here on the 9th, so that they can report it to me by the next week.
okay.
That makes sense?
Yes, sir.
So you're gonna, you still have over 30 days. Today's the 2nd. So, I mean, you really need to put pen to paper, and write down when you're gonna do it, where you're gonna do it, and make sure that it's approved. If you do it in Dallas, don't just go show up somewhere and say, I need a volunteer. Make sure it's an approved community service location. Otherwise, you could do all these hours and not get credit for any of them because it has to be verified by the probation department up there.
Okay.
Okay, does that make sense?
Okay, so my probation in Dallas, I just it has to be verified. My community service has to be verified through them. That way, you know what I'm saying, they can send it to y'all.
Correct.
All right.
Right.
Yes, sir.
And if you don't do it up there, then just, you can come down here and do it, and it doesn't have to be verified, because they'll tell you where to go to do it.
Okay. Yes, sir.
Okay, any questions?
Yes, sir.
All right, Mr. Rosser, we're gonna go ahead and take a UA test today, okay?
Yes, sir.
All right, so if you want to come on back here, and when he leaves, he'll go out that way. It's okay, what do you need? Yeah, I didn't say anything about classes, it's just about probate, it's just about community service and money. Okay? It's okay, good. And when he leaves, he'll exit out the back way, so if you want to wait in the hallway, he'll pop out in just a second. Mr. Campbell? All right, this is cause number CR 19-108, State versus Robert Baker Campbell. Mr. Baker, Mr. Campbell, a motion to revoke has been filed. Court finds that you are indigent at this time. And the court is appointing the Honorable Jonathan Manning to represent you. And Mr. Manning's not here today, so I'm gonna reset this case to Thursday, August 15th at 9 a.m. So we're gonna give you this notice of setting, sign that, and then be in contact with Mr. Manning.
Mr. Manning?
Manning. No, free to go. We'll see you back August 15th. Thank you. Brandy Baker. This is cause number CR 24-90. State of Texas versus Brandy Lee Baker. Ms. Baker, you have been indicted with a second-degree felony offense of possession of a controlled substance of penalty group 2 greater than 4 grams, less than 400 grams. A second-degree felony does have a range of punishment of not less than 2 years or more than 20 years in prison, and a fine, a possible fine not to exceed $10,000. The court finds that you have requested a court-appointed attorney based on indigency. Based on the information you provided to the court, under the law, you are not deemed indigent. So what I'm going to do today is I'm going to reset your case and give you an opportunity to go hire an attorney to represent you. Okay, so I'm going to give you until August 13th. All right, so you need to go meet with attorneys and get someone retained and bring them back with you. Otherwise, you also have the option to represent yourself, which I not recommend. And Miss Baker, you did finish your paperwork with Mr. West that you were signing outside earlier?
Yes, I did.
You have those conditions with you?
Yes,
Okay,
sir.
you're free to go. All right, for the record, cause number CR 24-28. Stephen Arkell Pickron for arraignment. I believe Ms. Tabraham has confirmed that Mr. Pickron is in the Lyncher unit serving a 5-year sentence out of Dallas with a projected release date of August 8th of 2028. So I'll reset this for arraignment, and then the state can decide if it wants a bench warrant. If so, then request that through Ms. Abraham.
Yes,
I'll set this out a little bit further. Set this to September 3rd. All right, cause number CR 24-50, State versus Edward Joseph Drummond. Mr. Drummond was set for pretrial today. The court did receive confirmation from Terrell State Hospital's court coordinator section that Mr. Drummond is currently in the Terrell State Hospital unit. So the court will not issue a judgment NISAS today. We'll reset this matter for August 13th for pretrial. Mr. Schmidt, any word on a Dallas Hightower? Okay. And are you ready on Mr. McDonald? Jason McDonald. Jason Wayne McDonald, CR 23-151, docket call.
Good, we're set for a doc call. We're gonna ask for an additional doc call. I think we're pretty close to wrapping up Mr. McDonald's business here.
Any objection from the state?
No objection, Your Honor.
All right, court sets Mr. McDonald for a final docket call. August 13th. 9 a.m. Mr. McDonald.
Oh.
I show that the probation pretrial release department is reporting that you didn't report in June. Is that correct? You didn't-
Oh, I reported yesterday. I rescheduled it. I had to go in yesterday.
You rescheduled your June appointment?
Yes, sir. It was yesterday when I reported.
Well, I know yesterday's July, but I'm saying in June, you contacted them and they said that they will reschedule you until yesterday.
Yes, sir.
Who did you
It
reschedule?
was, Mr. West.
Mr. West,
And
okay.
it was, I think on a Friday evening that I rescheduled and then I met with him Monday afternoon.
Did you make any payments yesterday?
Yes, sir.
What'd you pay yesterday?
65.
65.
Yes, sir.
Because I showed that you were a little bit delinquent, so make sure that you're not delinquent. Because if you paid 65 yesterday, that may be applied to your July payment, not your June payment.
Yes, sir.
But make sure that you're not delinquent.
Yes, Your Honor.
Okay, all right, ready to go.
Not be.
Mr. Schmidt gets back, we'll talk about Preston Wilson. I want to see if y'all have any updates on what y'all want to do. Well, let's wait for him to get back.
Sounds good. I'll see. I'll make a phone call real quick and see if, Tondo,
Updates.
yeah,
Mr. Blue? All right, this is cause number CR 23-201, State of Texas versus Daytona Wayne Blue. Mr. Blue, sir, if you'll raise your right hand, I'm going to place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Your name is Daytona Wayne Blue, is that correct?
Yes, sir.
And Mr. Blue, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jeff White. Are you pleased with Mr. White and the work he's done for you?
Yes, sir.
Feel like you've had enough time to talk with him about your case to the point that you understand all of your legal rights and everything that you have read and signed in this plea agreement today?
Yes, sir.
Do you have any questions before we go further?
No, sir.
Mr. White, do you believe Mr. Blue to be competent?
I do, Your Honor. I believe he's capable of making the decisions he's made today.
And you've explained to him his rights as they pertain to this case and also the advantages and disadvantages of a deferred adjudication plea?
We have, Your Honors. He understands that he is potentially looking at a 10-year sentence if he does not comply with the terms and conditions of probation.
And you believe that he's entering into this plea agreement intentionally, knowingly, and voluntarily?
Yes, Your Honor.
All right, Mr. Blue, you are charged by indictment with a third-degree felony offense of theft of property greater than or equal to $30,000, less than $150,000. And as Mr. White said, the range of punishment for a third-degree felony, if you were to be convicted and sentenced, it would have to be to a range of not less than 2 years or more than 10 years confinement in prison, with a possible fine not to exceed $10,000. I see the plea agreement in your case today is that you would plead guilty to this offense. In exchange, the state's recommending that the court review the evidence, defer a finding of guilt. That means not convict you as a felon today, but rather to defer a finding of guilt and place you on 10 years community supervision. And one of your conditions of community supervision is going to be to pay restitution in the amount of $59,699.84, joint and several with the co-defendants that you committed the offense with. Is that your understanding of the plea agreement?
Yes, sir.
In addition, you're going to be responsible for court costs of $290 and reimbursement fees of $90. All right, so Mr. Blue, understanding the plea agreement, understanding the range of punishment, how do you plead to theft of property greater than $30,000, less than $150,000?
Guilty.
Are you pleading guilty to this crime because you are guilty of committing this crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
Are you nervous today?
A little bit.
You're okay. Take a deep breath. I want you to really be paying attention to what we're talking about. Okay.
Yes, sir.
I don't want you to walk out today and have been so nervous that you don't recall what you've agreed to.
Yes, sir.
Right? You understand what's going on today?
Yes, sir.
I understand being nervous, but it looks like Mr. White has negotiated a plea here today that could be in your benefit greatly. So we're going to talk about that here in just a moment. Mr. White, well, the court's going to go ahead and accept at this time Mr. Blue's plea of guilt. Mr. White, any objection to the court considering the stipulation of evidence and admitting that into evidence?
No objections, Your Honor.
All right, the stipulation is admitted. The court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, just that the school district is supportive of the plea. Additionally, worked out with defense that once Mr. Blue has paid what would be, his share of the restitution, state would have no objection to modifying conditions of probation to be a little bit more relaxed. Obviously, he's going to be on probation until the entire restitution is paid. However, once he makes what would be kind of his part, we would have no objection to reducing the restrictions on Mr. Blue.
So I was going to inquire about that. So I see that it's joint and several with the other co-defendants, Trevor Blackman, Hudson Griffin, Christian Berkland, and Bryce Brewer. Is that correct?
Yes, I believe that's all of them, sir.
Yeah, so there's four other co-defendants. And so is it the intent of the parties that this approximately $60,000 be divided into $15,000 restitution amounts?
I believe so, sir.
But you're, despite what the judgment says, joint and several, it's your indication that if Mr. Blue pays his $15,000 towards the total restitution, that you're gonna keep him on community supervision until the remainder of the parties pay.
Yes, sir, that he would remain on supervision, but perhaps less often reporting or non-reporting or something, whatever he works out with the probation department. But that, yes, he would remain on probation until the entirety is paid.
Your Honor, our understanding was basically that once he paid his amount, and I believe since there's 5 people total, it would be somewhere around $12,000. Still be on probation, still on the hook for it if other people did not pay their share. Yeah, as I've explained to him, if everybody refused to pay except for him, he'd be responsible for $59,000. And he understands that. And it's our understanding that once he pays his amount, he will still be on probation on the contingency that the people did not pay theirs. He would have to be responsible for their part too. But he would not have quite the same restrictions that he is under probation. And this certainly would give all these people an incentive to hurry up and get this paid.
All right, so that answers some of my questions. So Mr. Blue understands that if these prosecutors are no longer here and Ms. Curry is no longer here and new prosecutors are here and none of the other, as you say, co-defendants pay anything, Mr. Blue understands that he could be legally obligated to pay the entire amount of restitution.
Yes, sir.
We understand that we're counting on the other people to do their part, but we understand if they don't, what happens.
All right, thank you, Mr. White. All right, court's going to review the evidence. All right, court, having reviewed the evidence, finds sufficient evidence to convict Mr. Blue of this offense. However, the court will follow the plea agreement and the recommendation of the state today. Court defers a finding of guilt on the third-degree felony offense of theft of property greater than $30,000 less than $150,000. Places Mr. Blue on community supervision for a period of 10 years. Orders that restitution be paid joint and several in the amount of $59,699.84 with co-defendants Trevor Blackman, Hudson Griffin, Christian Bergwin, and Bryce Brewer and their respective indicted cause numbers as reflected in the judgment. In addition, the court does order Mr. Blue to pay his court costs of $290 and reimbursement fees of $90. Mr. Blue,
Yes, sir.
how old are you?
18.
18. Are you in college right now?
No, sir.
No? Are you working?
Yes, sir.
What are you doing? Kind of work
I'm
you do?
just a welder helper.
Welder?
Welder's helper.
Welder's helper?
Yes, sir.
And what do you plan to do with your life?
Probably be in the oil field. I'm gonna try to.
Say that again.
I'm gonna try to go to the oil field here soon.
It's tough to start new plans in life when you're already potentially $60,000 in debt.
Yes, sir.
You know, there's people going to colleges right now that are paying that and getting degrees.
Yes, sir.
You're just paying that to stay out of prison.
Yes, sir.
So you're going to take this probation very serious, correct?
Yes, sir.
You understand as a young man at 18 years of age that there's a lot of things left in front of you as far as your career and family life, personal development. You understand that?
Yes, sir.
You understand that if you don't take this serious, people at this side of the table are going to take it serious.
Yes, sir.
And whoever's sitting here, whether it's me or someone else, is gonna be taken serious.
Yes, sir.
Understand that?
Yes, sir.
And as Mr. White said, if you violate any of the terms of your community supervision, you don't pay your restitution. You decide you're gonna drink alcohol, you're gonna commit a new offense, you're gonna do drugs, whatever. You violate, state can file a motion to adjudicate, to be able to convict you, to bring you back to court
Yes, sir.
and ask this court to revoke this agreement and place you in custody
Yes, sir.
and convict you of the offense and send you to prison anywhere from the minimum 2 years to 10 years.
Yes, sir.
Pretty serious. So when you wake up in the morning, I want you to be thinking about this.
Yes, sir.
First thing I want you to think about is God. It's the first thing I want you to think about. Okay.
Yes, sir.
And then after that, I want you to think about what you have to do to stay out of prison.
Yes, sir.
What you have to do to stay out of prison is written down right here. It's in all your conditions of supervision.
So,
That needs to be your checklist of daily things that you're doing. Community service, reporting, paying your probation fees, paying your court collection fees, paying your restitution. That really needs to be your daily checklist of things that you need to do
yes, sir.
to stay out of prison. Understand?
Yes, sir.
And I don't know what Trevor and Hudson and Christian and Bryce are gonna do with their life. And if they get the same deal, some of them already got the same deal, I believe. I don't know what they're gonna do and how they're gonna treat it. But I would hope that you would set yourself apart and decide that you're gonna take advantage of what the state is giving you,
Yes, sir.
what Grand Saline Independent School District is giving you, because you heard Mr. Hartwell. The school is supportive of this,
Yes, sir.
right? You went to Grand Saline, didn't you?
Yes, sir.
Did you graduate?
Yes, sir.
Drop out?
Yes, sir. I went home,
When did you drop out?
my sophomore year.
Sophomore year? Have you gotten your GED?
Yes, sir. I got my high school diploma still.
You did?
Yes, sir.
That's good. So Grand Saline Independent School District, you're one of their students, even though you dropped out. They're here with the probation department or with the state and the probation department saying that they're supportive of this.
Yes, sir.
They're not trying to put you in prison. They don't want to see you become a convicted felon, not be able to get a good paying job and lead a productive life. And the prosecutors have offered you this. Mr. White has done his part, and I'm approving it here today.
So,
So we've all done our part. All we can do now is put the ball in your court and decide what you're going to do with it.
yes, sir.
And you can either dribble that ball and score and get this behind you and move on in your life. This is just a blip in your history, or you can throw that ball out of bounds and end up in jail, end up in prison.
Yes, sir.
All right. So I'm telling you this because I want to impress upon you the importance of what's occurred in this case. And when you walk out that door, what can occur in this case. So it can be good, it can be bad, and you
Yes, sir.
get to decide which way that goes. Okay,
Yes, sir.
hear me?
Yes, sir.
Any questions, any concerns before we leave? Any questions from Mr. White, me or the prosecutors?
Yes, sir.
Anything that you don't understand?
Yes,
Now's the time to talk about it.
yes, sir.
All right, and when you get on probation, I want you to be a model probationer. I want your probation department officer to, when you walk in, I want them to smile and be happy to see you and know that you're making their job really easy. That you're doing everything you're supposed to be doing and that they're just gonna go through the motions of checking on you and send you on your way,
Yes, sir.
right? Make your probation officer happy because they can be a great resource for you and they can be a voice for you to this court.
Yes, sir.
Right. All right, Mr. Blue, you're hereby remanded to the custody of the probation department so they carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted with Deputy Martinez. And after that, you're gonna meet with the probation department.
You can call me anytime.
Yes, Your Honor. He pled guilty in his federal case, has not been sentenced yet. My understanding is that, those are typically set 3 to 4 months out. And I believe his guilty plea was taken very recently. So I'd ask maybe, a status in October, see if we have a sentence, and that could, depending on what's going on with that, could resolve this case as well. I don't have any information. I believe it's unrelated. But I can see if I can find more information for the next hearing, Your Honor. Thank you, sir.